Yes, Mr. Ramsden. Duty of care.
Thank you. I think I might overall meet my promise, but here we go. Duty of care. I'm going to deal really with this in outline and overview only, given that Mr. Charlton's going to say more about it. But there are some short points my clients wish me to make, and they are these. We say there is an intimidating range of hurdles facing TTL. The first is, of course, that its claim is in respect of an omission by developers to take positive steps, so it is a positive steps case. Second, it is, of course, a claim in pure economic loss, requiring the demonstration of an assumption of responsibility, the point that Mr. Wardell addressed in answer to my Lord's question, really linking the viability of duties of care in the event that he doesn't succeed with fiduciary duties. Thirdly, the duty is to be imposed indefinitely on an ever-changing group of individuals based across the world with no pre-existing relationship whatsoever with the claimant, with no history or necessary means of cooperating or coordinating as a matter of necessity. And we say this, of course, this is a pleaded and therefore assumed fact. At least the BCH, that's the Bitcoin Cash Network, did not even exist at the time TTL is alleged to have acquired the subject Bitcoin. And that is, for my Lord's note, the factual assertion of paragraphs 30 to 32 of the particulars of claim. That is core 7, page 90. Fourthly, the scope of the duty is as open-ended in the common law sphere of liability as one could imagine. I've already taken my lords to the particulars of claim in relation to fiduciary duty. If we look very briefly back in the particulars at core 7 in relation to common law duties, we start at paragraph 45. Sorry, we don't. We start at
45 is fiduciary.
It's fiduciary. It's 51. My apologies.
Yeah.
So the duty pleaded in 51 is the voluntary assumption by virtue of a proximate relationship and on the basis that it would be fair, just and reasonable, which requires the developers to do the following. But we see from the end of the main paragraph 51, that is not said to be exhaustive because it's including two obligations: putting in place appropriate arrangements for access to and control of digital assets, and secondly, protecting against fraud in relation to such digital assets and taking steps as to reverse fraudulent transactions. Again, when we come to relief, we'll see that that is even wider, but that's a pretty wide duty. As was observed yesterday, that is a wider duty than the claimed fiduciary duties. And when we look at the prayer, which is just over the page, that's core page 100 to 101. The common law duty, in keeping with the fiduciary duty, is in paragraphs 3 and 4, an order compelling the developers to take all reasonable steps to ensure that TTL has access to and control of the Bitcoin in the addresses, and an order that the developers take all reasonable steps to ensure that effect is not given to the fraud. And although, of course, that is qualified by the following sentence, it is, we say, an untenably wide duty. Fifthly, we say the duty is to be owed to an effectively unlimited class of persons in an effectively unlimited set of circumstances. As I indicated earlier in the context of fiduciary duties, a completely wide and untrammeled obligation to put right the loss of access to Bitcoin, however that might occur. And lastly, but by no means least, we say that there is no special reason to impose a duty, and we say there is no coherent claim that the duty would be a permissible incremental extension to existing established duties.
What do you say about the breach alleged in paragraph 53A, which looks like an allegation of, if you like, faulty design of the network?
It does. It does. So we would link that, and I think that's what gave rise to the product liability observation yesterday in the course of submission. And I would say that appears to be linked to the duty, the non-exhaustive duties pleaded in paragraph 51A. So if you link 51A, that's the putting in place appropriate arrangements for access to and control of digital assets.
So that's at the design stage.
That seems to be the design stage. And as I observed yesterday, what is offensive to principle there is that not only is that wider than the fiduciary duties, but it predates them. So they certainly arise materially before fiduciary duties might.
Does that matter? I mean, if you design something that you know people are going to use and it's faulty, you might have a liability to people who use it.
You might, and I don't say this is a sort of Henderson and Merrick case where you can only have tortious duties if they are coextensive and concurrent with contractual duties. So I'm not using that analogy, but I do say on the facts of this case and the way that applies juridically to the way the case is put, it would be very odd if duties at common law were to exist to a wider extent than fiduciary duties and predate them. So conceptually, no, it doesn't matter, but in practical terms, it would be a highly unlikely outcome.
As applied by the amendment, it looks as though it's addressing itself to a system defect in the future. That is to say,
yes,
not doing something systemically across the piece once there's been a declaration of ownership in favour of TTL. If there is.
Yes, indeed.
Which is rather different from how it might have looked unamended.
Yes, it is. And that's very much what I had in mind when we had the exchange yesterday, and actually to a certain extent this morning, on whether the patch applies, as it were, to a bespoke remedy to TTL or has to be adopted across the system. Their pleaded case on duty of care is that there needs to be a systemic change to the Bitcoin system, as I understand it. But again, it feeds into the point that this is a much wider duty. So just as I took my lords earlier to the pleaded case on fiduciary duties, it is worth, I don't want to do it now because of time, but in due course, my lords, I would invite my lords to pay as much scrutiny to the particular way both the duties and the breaches are pleaded in the duty of care. I do say if TTL fails on fiduciary duties, its duty of care claim inevitably falls away. But if there's any temptation to keep it alive, it is in many ways juridically more offensive to principle than the fiduciary duty claim. So those are the brief submissions we make in relation to duty of care, just to highlight the salient points that we say cause real difficulty in this case. That brings me to Quincecare duty. This is dealt with in our skeleton argument at paragraph 63. And what the court was confronted with at first instance, and only in oral submissions, was the attempt to analogize the current duty of care, and that was in its amended form, with a Quincecare duty. And from the observations we've just exchanged in relation to the ambit and nature of that duty, it's immediately apparent that what's pleaded here is not obviously analogous with the Quincecare duty. We say, unlike with Quincecare, there is no instruction to pay or indeed any event at all that triggers the alleged duties, save for, of course, the allegation of loss of access to Bitcoin. There is, prior to the notice, in this case, pleaded at paragraph 40 of the particulars of claim, no suggestion that the developers are on inquiry or have any relevant state of knowledge that might have enabled them to have prevented the hack. Now, the Quincecare duty classically arises if and for so long as the circumstances would put an ordinary prudent banker on inquiry. And indeed, we rely upon the recent decision of this court, which was, as the judge reflected, handed down after oral argument before her judgment, and that is the judgment in Philip and Barclays Bank, and indeed my Lord Justice Birss's judgment in that case. Now, that is for reference tab 20, and the particular paragraph we rely upon is paragraph 28, and given the court's familiarity with that case, I'm not going to turn it up now with time in mind, but at the heart of my Lord Justice Birss's analysis of Quincecare duty in that case was the relationship of agent and principal between bank and customer. And that has resonance with the case that was before the judge, Singularis, and the judge cites Singularis at paragraph 103 of her judgment. That is core 13, page 162.
So which paragraph?
That is at Singularis at paragraphs 87 to 88. And consistent with this court's judgment in Philip and Barclays Bank, the Master of the Rolls observed in Singularis that the limited scope of the Quincecare duty makes it obvious that it is only to protect the customer from the loss of its money, and that only the customer can vindicate a claim for breach of it. Now, the reason I draw attention to those two authorities is because, as part of its attempt to analogize the present duty of care with Quincecare, TTL says this has nothing to do, that is, the duty has nothing to do with a contract. And whatever else we're looking at, we're not looking at any contractual relations in this case. Well, we say that that may be strictly correct, but that ignores the reality, the foundation of the duty, which is either principal agent or customer of the bank. And the customer of the bank is the only person who can vindicate the right under Quincecare. We also say that, of course, Quincecare in its nature is a duty intended to prevent a wrong happening, rather than the ex post facto duty, which is sought to be imposed upon my clients. And I say that particularly pointedly in this case, because, of course, it was a whole year after the alleged hack that the letter pleaded at paragraph 40 of the particulars of claim arrived with my clients, the letter before claim saying, we've been hacked and you now need to resolve that issue for us. So a long way from Quincecare, and the attempt to analogize doesn't work. Can I therefore finally just tie up some loose ends which arise from our respondent's notice and on the issue of quia timid that my Lord Justice Popplewell raised yesterday, Mr. Wardell. Our respondent's notice is in two parts. The first, of course, addresses, we say, the lack of consequence to the final outcome if, contrary to our primary submission, the judge did not impermissibly make findings of fact. We say, for the reasons set out in that part of our skeleton, it makes no difference to the final result. I've attempted to articulate why that is by reference to the key features of the duty and the factual application of them in my submissions this morning. And I don't think I can helpfully add to what I said in my respondent's notice skeleton in that first section. The second section addresses the alternative case. And as I said this morning, I'm not prejudiced at this hearing in meeting it because I've drafted submissions in response to it. And what do we say about that? Well, I can be equally brief, relying primarily on what I say in my skeleton argument, which is essentially to say that if the alternative case is permitted, and if we are right in our fundamental premises, found our submissions in relation to fiduciary duty and duty of care, the new case makes no difference. Now, I say that not in any way resiling from my principal submission that the old case is obviously offensive to principle. It is simply untenable. That the only way this case could possibly be put is on the basis of the new case, that is the obtaining of, of a declaration first. But in my submissions this morning, I hope I attempted largely to address the factual premise of that new case. So all of the difficulties that I identified in connection with the objectively ascertained assumption of fiduciary duties apply to the new case. All of the expense, inconvenience, and improbability attached apply to the new case. And we say, again, if we are right about those fundamental premises, it makes no difference. Is it relevant that there is a quietemet injunction claimed? My Lord, I have to say, it was raised in submission before the judge, so our ability to respond to it was extremely limited, because it was put as a quietemet entitlement. That's what we responded to, and that's understandably what the judge addressed. But I entirely accept my Lord Justice Popplewell's point that it need not necessarily be one. I have to say, when the argument first emerged in oral submissions, I thought that it was a quietemet case because they were really saying, on the basis of a declaration as to ownership first, we might also apply for an injunction to hold the ring pending the obtaining of that declaration, so that quietemet principles would apply. Does it make a difference if it's actually a conventional final injunction? No. If we're right in our fundamental premises about the defects in the claim, it doesn't matter that it's a conventional injunction. The only significance of quietemet is that it presents yet further problems if it is a quietemet. But I'm inclined to agree with my Lord Justice Popplewell that it isn't. Mr. Wardell didn't commit, as I understood his submission, one way or the other, but seemed to acknowledge the point had some force. I'm happy for the court to adjudicate on the basis that it might or might not be. Probably isn't. It's probably a conventional final injunction. But it makes no difference. Well, look, would you give me just a second just to check whether there's anything else I ought to raise? Yeah, and the only point of emphasis I'm asked to make is that we, in curtailing my submissions in the way I have, and I hope efficiently and proportionately, we don't step back from or abandon any part of our respondent's notice. It's fully canvassed in our skeleton argument. So
yes.
I don't want it to assume less importance because I spent rather less time in it than I might otherwise have done. But I hope, as I said this morning, I've tried to use the time available to focus on what I think is likely to be of most assistance to you.
Yes,
So, unless I can assist further at this stage, those are my submissions.
Thank you, Mr. Ramsden.
Thank you.
Yes, Mr. Charlton.
My Lord, I only have a few points to make. I adopt my learned friend's, Mr. Ramsden's submissions with gratitude. I will keep to an order, but it is a miscellany of points so as not to duplicate what's been said before.
Quite. So we don't want duplication,
We don't want duplication.
hesitation, or repetition.
Amendment. Our opposition to the amendment is set out in our skeleton at 45 to 60. If I may develop it as follows. Firstly, we say that the proposed amendment is procedurally defective, and it's procedurally defective for the claimants to proceed against these defendants for declarations as to ownership. D14, who I represent, has not made any claim as to the ownership of the assets in question, nor have the other defendants. And we say it's insufficient for the claimants to come before this court and say, we want to have a declaration of ownership against the defendants, when those defendants have not asserted any claim to what is said to be owned. The bold proposition really is this, that when you want to declare ownership of something and it is in dispute, you have to proceed against the defendants or persons, companies, who are making rival claims. And as my Lord Justice Popplewell pointed out to Mr. Ramsden, there are indeed many claimants, rival claimants, to the Bitcoin in the one Feeks address. And the evidence for that is the claimant's own evidence in the supplemental bundle at tab 21, page 366. It's in Mr. Kane's first witness statement at paragraphs 196 to 188. I needn't take you there if the Lordships can read it in due course.
On this application, do we have to proceed on the assumption that the evidence of Dr. Wright is to be accepted?
Yes, you do.
So that these aren't credible claims?
Well, that is not a factual assertion. That is a question of opinion. So that's not a factual assertion which it is the basis of which your Lordships are being asked to deal with this application. So one has to be astute always to look to see what's a legal proposition, what is a statement of opinion, and what is an allegation of fact. In any event, it doesn't matter for these purposes that they're not credible. That's not sufficient, obviously, for the claimant's purposes, who are saying we need to come to court to get the court to say it's not credible. But the relevant defendants to that declaration would be those, whether their assertions are correct or incorrect, whether credible or incredible. The correct defendants are those people that have come up and said, actually, we own those assets. It's an obvious point, but I make it in any event. None of the defendants are alleged to be involved in the hack, which would be perhaps another reason why the declaration should be sought against them in relation to ownership. But as a matter of common ground, that is not the case here. Now, claimants plead that in paragraphs 47 and 53 of the draft amendment, particularly the claim, that D14 will be in breach of duty at such time as TTL obtains a declaration that it is the owner. But we submit that the declaration in these circumstances, the declaration sought against the defendants, is bound to fail. And in that regard, we invite the court's attention to the case of Bank of New York, Mellon and Esser, which your lordships have in the supplemental non-agreed bundle of authorities at tab 3 at page 101. Where Justice Marcus Smith at paragraph 21, which one finds at page 101, set out the powers to grant declaratory relief and said that they're discretionary, and then listed a number of reasons why courts should not grant the declaratory relief. And the relevant ones for our purposes are at paragraphs 1, 2 and 5, particularly at 5. One is that there must in general be a real and present dispute between the parties. That's not the case here. 2, each party must in general be affected by the court's determination of the issues concerning the legal rights in question. As far as D14, he's indifferent to the question of ownership. As far as he is concerned, he doesn't assert ownership. And then over the page at 5, the court must be satisfied that all sides of the argument will be fully and properly put. It must therefore ensure that all those affected are either before it or will have their arguments put before the court. For this reason, the court ought not to make declarations without trial. And then there's a quotation of Lord Justice Buckley and Wallerstein and Moore. So we submit for those reasons, the absence of the proper defendants, the declaration will not be made as to ownership in these proceedings against these defendants. And for those reasons, we say that the amendment must fail. Even if that is not the case, the question then arises as to whether or not a declaration can found a duty or indeed a breach of duty. And in answer to that question, we say the answer is no. Now, your lordships have already seen customs and excise against Barclays Bank, and perhaps I could just take your lordships to that authority in the agreed authorities bundle at tab 7, page 189, where Lord Hoffman at paragraphs 38 to 39 is dealing with the question of whether or not the freezing injunction that had been obtained and served on the bank could create a duty of care. To which the answer...
Sorry, paragraph switch?
It's paragraphs 38 to 39.
Thank you.
To which the answer was no. And in paragraph 38, he deals with the notion of assumption of responsibility and says that's not enough. He says just below C, in the present case, however, the duty is not alleged to arise from anything the bank was doing. It's true that the bank was carrying on the business of banking, handling money on behalf of customers, but that is not alleged to have been either necessary or sufficient to generate the duty in this case. Not necessary, because if such a duty is created by notice of the freezing order, it must apply to anyone who has possession or control, etc. Not sufficient, picking it up at E, because there is no suggestion that apart from the freezing order, the bank can carrying on its ordinary business would be under any duty to protect the position of the commissioners. And then he deals with the what he says is a compelling analogy with Stovin and Wise. Law of negligence does not impose liability for mere omissions. It's true that the complaint is the bank did something, it paid away the money, but the payment is alleged to be the breach of the duty and not the conduct which generated the duty. The duty was generated ab extra by service of the order. And then the question of whether the order can have generated a duty of care is comparable with the question of whether a statutory duty can generate a common law duty of care. He then deals with that and then says, just above H, likewise, as it seems to me, you cannot derive one from an order of court. The order carries its own remedies, which does not extend any further. So we submit that the granting of a declaration as to ownership is nothing to the point. It founds no duty. Now, the question arises, one supposes, that in this particular case, and I believe it's put in this way, that it's the breach which arises on the making of the declarations to ownership. Well, if that's right, one has to look to see what the duties alleged are, both fiduciary and tortious in this case. And it would be a duty that arises, a fiduciary duty and a duty of care that only arises where there has been a subsequent declaration as to ownership. Now that is a novel duty, not known in law. So I understand my learned friends to be saying the duties exist at the point where I believe the BCH in my client's case came into existence. But if it's a duty that arises then that is not actionable until the court makes some form of declaration, then that is a very, very extraordinary duty indeed. So one, and certainly not one that's been pleaded. Paragraphs 45 and 51, I know your lordships have the duties that have been pleaded, but they certainly don't, they're not framed in a way which says, well, you have the duty at this stage, and it's actionable only at a later stage when the court decides on a question of ownership. That is entirely not. That brings me round to a point which Mr. Ramsden adverted to, but it is an important point to understand that the amendments that are proposed are in response to Mrs. Justice Falk's analysis, correct analysis in our submission, that the duties proposed by my learned friends of the claimant are fatally flawed because of the inherent requirement that defendants have to determine questions of ownership and what to do with assets. So it was in response to that late realization of that fundamental problem that these amendments have been proposed. And of course, as your lordships already have, Mr. Justice Falk, in deciding there were no duties, as alleged, did take this point into consideration of judgment, paragraphs 80 and 105. As your lordships will have seen from our skeleton argument, we say the amendments in any event don't deal with the problems that Mrs. Justice Falk identified correctly. That's for the same point that I know your lordships have, which is that even if the amendment is allowed, even if the case goes forward on this newly pleaded basis, it still doesn't deal with the fundamental problem identified by Mrs. Justice Falk, which is that these defendants will still have to take a position on the question of ownership. So it doesn't do away with the problem which it was designed to ameliorate. And we set out, I don't need to take your lordships to it, but we set out our explanation of that position at paragraph 54 of our skeleton. That's all I want to say on the proposed amendment. In relation to the duty of care, and I will move between duty and care and fiduciary duty, if I may. I'm not taking your lordships to the law, but I'm taking your lordships to an overview of the tortious position and then some points on fiduciary duty. They all centre, or they all come back to the fundamental analysis is what were the developers' roles, what were their duties, was there an assumption, was there an undertaking in relation to property. That's the framework. Paragraph 9 of our skeleton, your lordships will see that we make some observations about the wide and nebulous terms in which the tortious duties are pleaded. Those, we say, are obvious from the face of the way in which the duties are pleaded, and I don't need to take that point further. However, it is a signal feature of the claimant's case in relation to duty of care that there is no causal connection between the alleged loss of the private keys and the duty of care that is said to have existed. Normally, one has a duty of care being breached, as a result of which loss and damage is suffered, for which damages are claimed. Here, however, we have a break-in and a deletion of private keys that would have occurred irrespective of whether the duties, both fiduciary and tortious, were in place and being performed unimpeachably. So when one looks at the pleaded duties and say, well, would they have prevented the loss of the private keys, the answer is no. And just to remind your lordships, the duty of care, at least, is expressed in terms of putting in place appropriate arrangements for access to and control of digital assets, allowing access to owners to those assets, and protecting against fraud. The additional element in the tortious duties pleaded, which we say is so mischievous and quite rightly struck down, held to be a serious issue, is not only in relation to those duties, but in relation to paragraph 51b of the particulars of claim, which adds to the tortious duties, almost by way of an aside, that developers were under a duty to take steps to reverse fraudulent transactions. Now, that is a huge leap, we say, that is not justified by any jurisprudence in England and Wales. At the moment, there has not been a fraudulent transaction to reverse. We're not talking about the hacking of computers or the burglary and then the hacking of computers and the deletion or taking of the private keys. that's not a fraudulent transaction. There has not been a fraudulent transaction, and it's common ground that both the Bitcoin in the one fix address and the Bitcoin in the 12 IB7 addresses have not been moved since the alleged break-in and the alleged theft. And that's recorded in the judgment of paragraph 31, core 145. Nor, we say, can the alleged break-in and hack of Dr. Wright's computer be accurately described as fraud. Fraud involves some sort of deception. So, again, we say that this duty of care, very wide terms, nebulous terms, including this reversal of fraudulent transactions, simply doesn't arise out of any of the pleaded facts which the claimants rely upon. But even if I'm wrong about that, and let's assume for a moment that there has been a fraud, that TTL was deceived into transferring the Bitcoin in one of both addresses to a third-party address on promise of payment of 20 million, which didn't, in the event, appear. Let's assume that that is the basis of this claim. That is a transaction, that fraudulent transaction, is one that takes place outside the network. The only thing that is recorded in the network is the actual transfer, the actual result of the agreement to buy and sell. That is what is recorded on the blockchain. What I'm getting to is that where off-chain or over in a corner a deal is done, buying and selling, or on an exchange, what I'm getting at is that these are transactions which the duties alleged are required not so much to reverse, but to provide an insurance policy in respect of.
Mr. Sean, sorry, can I just understand? I think I do understand the point about insurance, I get that. But you said, at least it sounded like you were saying that because the blockchain changed a record, it's really nothing to do with fraud. That's what it sounded like. No. The fraud takes, because the one person lies to another and convinces them to agree to pay the money and not get what was promised. That's all not happening on the blockchain.
The 20
all
million.
that happens on the blockchain is that the transaction's recorded, and somehow that means that's nothing to do with fraud.
I'm sure I did say that, and if so,
you didn't say those words. Don't worry about that. But that's what it sounded like.
The money doesn't go through the exchange. The promise to pay doesn't go through the exchange. Sorry, the blockchain. Leonard Jr. is absolutely right to correct me. The point that I was seeking to make is that if there's an agreement to sell for 20 million, that money doesn't get paid through the blockchain or the software. It's outside of the network.
Right.
It's the transaction, the actual transfer of the asset, which is fraudulently induced, which is recorded on the blockchain. And Her Ladyship below made it abundantly clear, there's no challenge to that, paragraphs 18 and 20 of the judgment, that is how the blockchain works. That is what it is there for. And the software that the developers have alleged to, or are alleged to control, is the blockchain software which records the transaction.
But the only reason you can't spend the money twice is because of the blockchain.
Indeed.
So it's not quite right to say that it's not a simple. I mean, the judge's judgment, of course, is, I think, as you said, it sounded right to me, if I may put it that way. It didn't sound like there was a problem with the way it was being described. But the way you're describing it seems to be, which is not what the judge said, I don't believe, is divorcing the transaction, the payment transaction, completely from the blockchain.
I don't mean to divorce it completely, because I fully accept, and I hope I've just submitted correctly, that it is the transaction that is recorded in the blockchain.
Yes. But
the deal, the agreement to buy and sell, and the exchange of money takes place over there. I'll come on to what we control in a moment, as pleaded by the claimants, because that's an important point. So If I may pick it up at the point that I was making about the insurance point, which is readily understandable, what we have here is, in truth, TTL losing its private keys. That's the valuable bit. Those are the keys that enable it to do what it wants with its Bitcoin. And we say that's got nothing to do with the way in which the network operated and controlled, allegedly by the developers, works. And we would go further and say that there's absolutely no problem at all unless and until an owner of Bitcoin on any of the networks is either very careless or unfortunate enough to lose or be deprived of those private keys. Now that's the setting for some very quick observations about the nature of the duty of care. I don't feel I should be delivering any sort of anything other than very small points on this.
Yes.
But your lordships will be fully aware that the duty of care cases, both cited in the judgment and indeed that we have been looking at today, all involve a harm caused by a third party, allegedly as a result of a breach of the alleged duty by the defendant. So if you take Smith and Littlewood's, for example, considered by Mrs. Justice Falk at judgment paragraph 87, with the following two other cases, Stoven and Wise and N.B. Poole. In Smith and Littlewood's, you had a disused cinema, vandals set fire to it, which damaged next door buildings. The allegation of the duty was against the owner of the disused cinema, who should have taken, it was alleged, more care to ensure that it wasn't broken into so that vandals could set it alight. In relation to Stoven and Wise, that was a Highways Authority case where there was a mound of earth by the side of the road which obstructed viewpoints. The Highways Authority had it in their power to remove that obstruction and remove the danger that had been created by the existence of the earthen mound. In N and Poole, you have a local authority moving a family into accommodation next to a family who were antisocial, and that family that was moved in was subject to abuse and harassment. So in all of these cases, there is that element of control which founded or didn't found, in the case of Smith and Littlewood, the alleged duty of care. In other cases, Dorset Yacht, don't need to go there, it was the probation officers who failed to supervise their charges, who went off in a yacht and boat and damaged boats belonging to the defendants. In Michael and Chief Constable of Wales, you've got a 999 call where the claimant was saying her ex-boyfriend was aggressive. It was graded G1 response, i.e. immediate, and then downgraded by the defendants to G2, i.e. respond in 60 minutes. Supreme Court held 5-2 against the duty of care. And then in Robinson, Chief Constable against the Chief Constable of Yorkshire, you've got a passerby who was injured by police officers in a busy shopping street in a town centre when trying to arrest a suspect, duty of care held. And then in Begum, you have the creation of the hazard by the owners of the ship who are sending it to the only yard that is going to dismantle it, and knowing that that was a dangerous place for that ship to be sent. So in all of those cases, it's the duty which is said to be in existence, breach of which gives rise to the harm. You do not have that in this case. Now, my learned friend, Mr. Wardle, says that the judge should refer to any of those cases because they're not about economic loss. Well, that doesn't help my learned friend at all. For economic loss, the test is even harder than those more domestic cases to which I've just referred. So we submit that the incremental approach is even more important where relief claimed is pure economic loss. But by reference to the earlier non-economic loss cases, one sees immediately the nature of the problem which the claimants cannot surmount. The learned friend has just referred to Quincecare and Philip and we had understood the claimant's case to be based on tort, on a pure extension of Quincecare and Philip. I'm not sure that in the time available, that there's much need to go into these cases, but perhaps I can just take it very quickly and say the following, submit the following. First, obviously in Quincecare and Philip, there was a direct link between the duty alleged, the breach of that duty, and the loss. Secondly, that in both cases, there was a customer and a bank and a contract. Thirdly, both cases were on inquiry cases where it was alleged that the circumstances of the instructions to pay were such that the bank should have been refrained from making payment without investigation. So we've got a very different position, fatally different position in this case, where there is no relationship of banker-customer, no relationship of agent and principal, no contract, no instruction to do anything that might have triggered the obligations to take care, no question of being on inquiry, no question of what the developer's state of mind was at any particular time, which was the central point in Phillips, paragraph 76. No question of developers having to consider whether to investigate whether a third party was making a dishonest or misappropriating request or request for transfer. That's all I propose to say in relation to duties of care. May I then turn to the nature of the relationship and this issue of entrustment, which cuts across both tortious and fiduciary duties. Mr. Wardell was critical of the learned judge at paragraph 72 of her judgment. Sorry, 73 of the judgment, starting page 155, last line, 156, where she said, further and to the extent relevant, I do not think that Bitcoin owners can realistically be described as entrusting their property to a fluctuating and identified body of developers of the software, at least in the sense and to the extent claimed by TTL. Now, we submit that that is a perfectly justified position to take. If you do not know who you are entrusting your asset to, and if you know only that it is a class of persons, that that class of persons is fluctuating, so you've got fluctuating and unknown, we say, for the purposes of fiduciary duty, it is obvious that there's been no entrustment. It's quite impossible to entrust anything to somebody you don't know. You might entrust something to, say, High Court judges, but even then, you don't know who they are. They may retire, they may die, they may arise, new ones may be made up. It's quite impossible for anybody to entrust anything, I would say, for the purposes of fiduciary duty, to an unidentified, fluctuating class of individuals. And that was a perfectly reasonable and proper point for the judge to take, and it's fatal to the claimants on this point. But in fact, the judge...
Is that right? I mean, if you consult a firm of solicitors, there may be partners who retire, there may be assistants who give you the advice, but that doesn't matter, does it?
Well, that's a firm of solicitors. It's a partnership. Yes. You know the name of it. You know who the partners are. The partners may be a fluctuating class, but the firm has an identity, a legal entity, legal identity, irrespective of the changing nature of the partnership. And of course, it may be an LLP, in which case partnership doesn't arise. But that wasn't the end of the judge's analysis, because what one has at the beginning of the section in which these observations, all of these observations, are made, is the judge saying in paragraph 72, first, it's very hard to see how the case on fiduciary duty is seriously arguable, detailed consideration now given. I concluded that my initial impression was correct. Taking all the features relied upon by TTL fully into account, and assuming in its favour that it would be able to establish the facts on which it relies in trial, I'm unable to conclude that TTL has a realistic prospect of establishing that the facts pleaded amount to a breach of fiduciary duty owed by the defendant. So she's there saying at the beginning of this section that I'm taking into account all of the matters that are relied upon by TTL. And when one comes to look at those matters, they are both in the pleadings and the judgment. Paragraph 18 and 20 of the judgment I adverted to a moment ago. But paragraph 18 on page 142 sees the judge setting out the claim, under the heading of the claim, digital assets in the network, and reciting effectively what is in the pleadings. And she says in paragraph 18, blockchain constitutes a public registry recording every transaction on the relevant digital asset. However, whilst the blockchain will show that the transaction has taken place and therefore the location of the asset on the network, it will not disclose the identity of the parties to that transaction. Instead, the assets are shown to be held at a digital address. Addresses have both public keys which identify them on the network and private keys, knowledge of which allows dealings in assets held at that address to occur through the use of a digital signature. Both forms of address comprise a series of letters and numbers. That's a statement of effectively what's in the pleading. And paragraph 20, she recites TTL's case as to how the networks came into being, and she says, she gives the various dates, I'll come back to those in the pleadings, but she says in line 6, the effect of copying is that all historic transactions up to the point of creation of an additional network are the same as for the network from which the blockchain was copied. This is the reason that all four networks are involved here. TTL's case is that the relevant assets were held on the BSV network and have been replicated on the others through the process just referred to, including in the case of BCH ABC Network after the hack occurred. I should clarify that whilst this is TTL's case, 15 defendants, 15 and 16 pose that. So when one looks at the pleadings accurately recorded, we say, in these passages of the judgments, we see that the one Feeks address, or the assets in the one Feeks address, were purchased by Dr. Wright in February 2011. The BCH network came into existence on the 1st of August 2017, so some 6 years later. And in relation to 12.1b7, the relevant assets were obtained by Dr. Wright prior to February 2011, and your lordships will see that pleaded in the particulars of claim at paragraphs 30 and 31. Now, it is a feature of the airdrops, as Her Ladyship correctly recorded, that when you create the new network, you copy the ledger. So if there are 20 Bitcoin in an address that belongs to the Dr. Wright or Claimant, Dr. Wright would Claimant get 20 Bitcoin, an additional 20 Bitcoin, on the new network. And that's also pleaded by the claimants in the particulars of claim. And sorry, I'm going for paragraph 15 for your lordship's note. So the way in which these assets, certainly in relation to the BCH network and certainly in relation to the ABC network, allegedly controlled by defendants 14 to 16, the way in which those assets were entrusted was nothing to do with anything that Dr. Wright or TTL did, it was because the networks were created and there was a copying of the blockchain. Now, it's at that point, of course, when the blockchain is copied and the new networks come into existence, that these fiduciary duties are, and tortious duties are alleged to arise. And I've made the point on entrustment. Where was the entrustment at that stage? There's nothing, absolutely nothing that the claimants did by way of entrustment.
By way of?
Entrustment. They took no positive step. They took no step at all. The further point, and this perhaps goes to my Lord Justice Popplewell's point, as to whether or not the issue of control, or the relationship, needs to be looked at the point of the hack. We submit that's not the case. But even if it were the case, it is, again, pleaded by the claimants that the claimants, neither the claimants nor indeed Dr. Wright, did anything, made no transactions on certainly D14's network or D15 or 16's network, or indeed any of the other defendants' networks, from the time at which the assets were acquired, or in 2011 or before. And again, that's their pleaded case, that the acquisitions were made in the way that's been pleaded, and then from 2011 onwards, nothing. No interaction with the software, no interaction with the blockchain, no interaction with the developers, no interaction at all. And that's true, of course, in relation to the transaction between Dr. Wright and TTL, where there was a declaration of trust. The ownership appears to have passed. We can't admit that, we simply don't know. But assuming that's the case, TTL is the owner. But that's not something that's registered on the blockchain. It's something that happened over there. Yeah. So again, when you look at what TTL did, it's done absolutely nothing. It's not Dr. Wright. TTL is simply the beneficiary of, one assumes, some sort of deed, some declaration of beneficial ownership in favour of TTL.
Well, could it be said that doing nothing, i.e. leaving them there, was the entrustment?
Well, that's a question of whether, when one...
If one's got entrustment at all. But
if one's looking at entrustment. Well, in our submission, that might be true in relation to the original networks upon which, to which the assets were transferred. On which the transaction was recorded, the original transaction, which Dr. Wright entered into when he bought the...
But we're not concerned with those Bitcoin. They're not the subject matter of the current proceedings, are they? The subject matter of the current proceedings are the new Bitcoin.
Well, no, they were the subject of the current proceedings in relation to D1. But that case is against D1 settled. D1 is...
Yes, but so far as your client's concerned.
Yeah, as far as my client's concerned,
it's the new Bitcoin that arise out of the hard fork.
Yes, so I don't... My client could not possibly have had any sort of duty prior to the creation of BCH, which was on the 1st of August 2017 as pleaded by.
And I don't think it's suggested that they did, but you say that there therefore can't have been any entrustment from that date because TTL did nothing thereafter.
They did nothing. They didn't do anything. They didn't do anything in relation to the assets on the blockchain. They were bought in 2011 on another blockchain, which was then copied, and they got them gratis. There was no payment, and they did nothing with them thereafter.
But if I have some shares which are being looked after by someone, and there's a 2-for-1 rights issue, they're looking after the new shares for me, aren't they? Even if I don't do anything about it.
Well, your lordship's example is, firstly, you would have paid consideration for the shares to be looked after, or there would have been an agreement with the person. If it's the company that you're talking about, there's no fiduciary duties owed by directors of the company to shareholders. I'll come on to that in a moment. Answer to my Lord Justice, Lord Lewison. Yes, my learned friend sitting behind me says it's shares in the same company. It's not a different. So it's in this context that TTL says that for tort there's been an assumption of responsibility. Effectively, we say to insure against loss of private keys or fraud. And for fiduciary duties, it says that D14 is undertaken to undertaken to act for TTL in circumstances which give rise to a relationship of trust and confidence. And my Lord, for our purposes, we would commend Lord Justice Leggett, as he then was, judgment in Kent, which, if I could take your lordships to very quickly, it's agreed authorities tab 112.
Tab?
That's tab 1,
Tab 1.
page 12. Mr. Ramsden gave you the paragraph references, but they're worthy of further consideration. 157, 158, and 159. 157, in considering the submission, I bear in mind that it is exceptional for fiduciary duties to arise other than in settled categories. That's common cause with Mr. Ramsden's submissions. 5 lines down, the categories do not include shareholders either in relation to the company in which they own shares or to each other. Whilst it is clear fiduciary duties may exist outside such established categories, the task of determining when they do is not straightforward, no generally accepted definition. And then citing well-known arguments you've heard already, your Justice Leggett then says it begs the question, paragraph 158, despite saying in Matthew that fiduciary is defined by the obligations to which he's subject, not the other way around, Lord Justice Milligan did give a general description of a fiduciary as someone who's undertaken to act for or on behalf of another in a particular matter and circumstances which give rise to a relationship of trust and confidence. We say on the basis of the analysis I've just given, Your Lordships, that doesn't arise here. That's then cited in various cases. Paragraph 159, thus fiduciary duties typically arise where one person undertakes and is entrusted with authority to manage the property or affairs of another and to make discretionary decisions on behalf of that person. They're pausing there. That's a very important passage in the context of this case. The assets which are the subject of this litigation are controlled by the person that has the private key. The developers have not ever had private keys. The software that they operate does not generate private keys. The private keys are part of the wallet, which anybody can open up and obtain from the internet.
Unless I've misunderstood it, there doesn't have to be a wallet.
I'm sorry?
It doesn't have to be a wallet at all, does there?
Well, there has to be an
There has to be a
address.
private key, and there has to be an address, but an address isn't a wallet.
No, but sorry, with the wallet, your Lordship is absolutely right to pick me up on it. The critical points are the address and the private key.
Yes.
You get that with the wallet. Not always, but that's the normal way that people do.
Yes, I understand most people use a wallet, but the address isn't the same thing as the wallet.
No, it's not.
The address is where the number is, which is the amount of bit.
Correct.
And the wallet is holding the private key.
Correct. And then the last point only, and I'm very conscious of the time, last line on page 159, fiduciaries are also liable to account for any profit obtained by themselves as a result of their position. I'm going to sit down, if I may just make one very quick point, and that is that the case that's advanced by the claimants on payment dealt with by the judge at paragraphs 126 to 128 of the judgment. We say that no fiduciary duty can arise in circumstances pleaded by TTL because paragraph 24 of the particulars of the claim, they plead that the developers receive payments in the form of sponsorship, grants or donations, or are employed by digital asset infrastructure companies. And Mr. Kane, at 50 supplemental bundle 2, tab 7, Kane 153.1, says Dr. Wright believes that those organisations and the BTC developers are being paid as a way to influence BTC. So just picking up that last point from the Justice Levy's judgment, money is being made by some developers from sponsorship or other payments by reason of their development activities, which we would say is totally inconsistent with the existence of fiduciary duty, because they're making money out of their role as developers, not for which is totally inconsistent with the undivided duty of loyalty.
Why?
When you're receiving money from a party to make a software change, that is not a change that is one that your other Bitcoin owners have been requesting you to make. You're not going out to those Bitcoin owners and saying, actually, is it all right if this change in the software is made? And they're being paid for those software changes.
But if that's the way the system works, one might infer consent from those who use the system, in the same way as the estate agent is able to act for two competing principles.
There can be no consent unless they know in advance what the position is, and they don't. Well, I'm very conscious of the time. There's my submissions in this.
Thank you. Yes, any reply, Mr. Wardell?
Yes, a few points. Just get organised. My own friend, Mr. Ramsden, started off by saying, or referring to our three formulations of the fiduciary duty. You'll recall he said that yesterday and again today. This is a mischaracterisation of our case. We never suggested the test of assumption of responsibility. We never suggested the test was just assumption of responsibility or mere imbalance of power. We've consistently put our case on the basis of an entrustment of property by the beneficiary in circumstances where, due to an imbalance of power, he is at the mercy of the person to whom he is entrusted the property. This is how we've pleaded the case, how we put the case below, and how we put the case before you. There's been no change in our position at all. Confirmation that there's been no change of our position could be found in paragraph 64 to 65 of the judgment. Call bundle tab 13, page 154. The judge recites precisely the same case that I put below, which is exactly the same as the case I've argued before this court. Our approach, we say, is based on and is consistent with Matthew, the 3 limb test in lap minerals, which was adopted by the Court of Appeal in Rex Goose, and the judgments of Mason J and Dawson J in hospital products, the first of which was approved by Lord Justice Leggett in the Kent case and by the Supreme Court of New Zealand in Chancery. The dictum from Grimaldi, adopted by the Court of Appeal in Lectimarchi, is also consistent with this analysis, and it is only looking at one facet of a fiduciary duty, namely the abnegation of self-interest. There was no suggestion in Lectimarchi that the court was seeking to find that the true test was different from the way we have put it. So it's both Court of Appeal in Lectimarchi and the Supreme Court. My learned friend submitted we were overstating the importance of imbalance of power, but then immediately took you to the judgment of Mr. Justice Mason in the hospital case. But that judgment is all about imbalance of power. I'd invite you to reread it. It's all about imbalance of power and vulnerability. And finally, I'd remind you, a point I'm sure you've got in mind, that most of the authorities we've looked at have all emphasised that there is no one certain test which is of general application when deciding whether or not ad hoc fiduciary duties are owed. See in particular paragraph 75 of Chancery and Fay. At that point is made very clearly. So that's point one I want to deal with. Point two is the farmer analogy. With all due respect, the farmer analogy does not work. The farmer analogy is a situation that involves contract, it's purely commercial. As I've repeatedly said, the authorities make it plain that different considerations apply in a commercial context. It doesn't mean you can never have a fiduciary duty in a commercial context. You're much less likely to. See Lord Justice Leggett in Kent, paragraphs 164 to 165. The farmer analogy, there's no question of assets being entrusted to the supermarket. In the farmer analogy, there's no vulnerability to abuse. The vulnerability to abuse only comes about if you've had entrusted assets in circumstances where there is an imbalance of power. My learned friend then spent quite a lot of time dealing with freezing injunctions. He made the point that we can get relief elsewhere. Even if we could, that has at best marginal relevance to the question before you as to what duties are owed by the developers. In any event, it is completely unrealistic to think that we can get relief elsewhere. In many cases, the identity of the hacker will not be known. Since the developer's case is that a freezing order will have no impact on them, there's nothing to stop the unknown hacker running off with the assets. If he does, it's possible that Bitcoin will turn up on some exchange somewhere, and it's possible that at that stage a victim might be able to take steps to find out sufficient information to recover his assets. But of course, much depends on what exchange and what information is held by it and whereabouts in the world it is held. And it's also entirely possible that on our facts, the hackers won't be able to break the algorithms behind which the private keys are held. So it may be that TTL's digital assets will never be spent, will never be stolen, but the fact remains that TTL cannot access its property. As things stand, the only remedy open to TTL is one against the developers. And the oddity of my learned friend's submissions is this. They say, yes, we're in a position to help. We can restore your ownership. But instead of us doing that, you should be chasing shadows around the world. So that's the freezing injunction. We then look at the patch point. My learned friend Mr. Ramsden argued to say the patch cannot just be applied to us. It has to be applied system-wide. That's not what the evidence says. The evidence is that a patch can be written for TTL alone. I'll take you to two brief references in a moment. Where the confusion arises in my learned friend argument is because of an entirely separate point they ran below as to whether miners or nodes would be willing to adopt the patch, to adopt the rewritten software. And that's a point dealt with by the learned judge in paragraphs 34 and 35 of the judgment. And it's quite clear that the judgment proceeds on the basis that what we say about that the miners would adopt any changed software, is right. The miners are in the business of generating income by investing at great expense in huge server farms that eat up a huge amount of electricity. The idea that they would refuse to accept a patch and risk not being rewarded for mining is, we say, completely unreal, but in any event is a matter for trial and not for this court at this stage. And so far as the evidence is concerned, can I just show you one passage at Supplementary Bundle 1, tab 3. Sorry, it's Supplementary Bundle 1, tab 1, page 3, and it's paragraphs 67 and 68 in the first witness statement of Craig Wright. At 67 he says, therefore it's wrong to say that Bitcoin or other digital assets can be transferred using the private key. There's nothing to stop the developers from including a patch to the computer code which operates the network to enable control of the asset to be returned to the rightful owner. 68, it's not technically difficult to code such a patch. In fact, it's very easy. And whilst we're there, can we look at tab 10? Paragraph 9.1 of the witness statement, fifth witness statement of Sophie Jane Eyre, the defendants broadly accept that it is in theory possible to write software which would reallocate assets to another address. So this court has to proceed on the basis that a patch can be written for the benefit of TTL alone, and has to proceed on the basis that that rewritten software would be acceptable and accepted in practice by the miners. So that's the patch. My learned friend then says that we are being inconsistent in respect of one of the clients, that's Mr. Maxwell. And he repeatedly took you to the example of Mr. Maxwell. Our case is that Mr. Maxwell remains one of the controllers. That is different from being a core maintainer, which may connote control, but not necessarily so. So, in the event, his numerous references to Mr. Maxwell are effectively a jury point, and is quintessentially a matter for trial. You can't possibly get a handle today on the question of whether or not we're right when we say that Mr. Maxwell is an appropriate defendant. My learned friend then makes a short point about the developers not being formally appointed. But there's no need for a formal appointment when you're asking the question of whether or not, by undertaking a specific role, you thereby are obliged to act qua fiduciary. There's then a very important point that came up in the course of submissions. Is this an evaluative exercise or not? And in answer to a question from my Lord Justice Lewison, Mr. Ramsden said that the appeal was against an evaluative exercise and that the court should be wary of intervening. He's completely wrong about that. Whether or not developers owe fiduciary duties, or arguably owe fiduciary duties, is clearly a question of law. As is the question of whether they owe a duty of care. And therefore the issue for this court is whether the judge was right to conclude that no such duties are owed to such a degree that the claim is effectively susceptible to summary judgment. And I'd draw your attention, just one example if I may, to the judgment of Lord Justice Birss at paragraph 77 of tab 20. This is the Philip case, and it's page 740. Authorities bundle. In paragraph 76, questions asked. One aspect of this case was the submission that allowing the appeal would involve either identifying a novel duty of care, or at least an unwarranted extension of the duty beyond the limits of the right approach to the development of the law of duties of care. And at 77, line 4, the learned judge, my Lord Justice Birss, says this: although the instance of a duty of care is a matter of law, well, as is the question of whether a duty of care is owed here, as is the question of whether or not there's a fiduciary duty here. And notably, in my learned friend's written argument, they accept that they were dealing with points of law. See paragraph 15 of their skeleton argument. So there's an opportunistic attempt to try and divert the debate. And my learned friend relies on Lord Briggs in Vedanta to support his submission that this is an evaluative exercise. There's absolutely nothing in that point. If we can get Vedanta and the Supreme Court back up. And we need to start at paragraph 12, the judgment. And you can see clearly what the judge is talking about. And that's on page 590. And what is said is this: Judicial restraint is of particular importance in relation to jurisdiction disputes, which wholly exceptionally reach this court, in particular in cases such as the present, where the Court of Appeal has already concurred with the fact-finding and evaluative analysis of the first instance judge. The essential business of this court is to deal with issues of law, rather than fact-finding or the re-exercise of discretion. The pursuit of detailed matters of factual or evaluative analysis in this court is therefore inappropriate, both because it's likely to involve a needless and useless misapplication of parties' time and resources, and because
Well, I think what's important here is that at first instance, Mr. Justice Coulson rejected the jurisdictional challenges. He said there's enough here to permit service out.
Yeah.
And what the argument was that if he drilled down deeper into the claim, he would have seen there wasn't anything in it.
Yes, and that's a criticism of his evaluation rather than the question of a point of law. And what Lord Briggs is saying in 13, the court should be wary of dealing with what is essentially a matter of evaluation dressed up as a point of law.
Well, he's
view is
also saying you've got to be proportionate about these applications. This is only an application about service out. You can't have a full-scale trial to, even on the question of law, to decide whether or not it's right. This is supposed to be a relatively speedy procedure.
Yes,
First instance judge must balance proportionality.
yes, but that must be, if I may say so, read in context. Look at the beginning of paragraph 13.
I think it's a point that's in your favour.
Oh, sorry. I do apologise. Learn to listen. But thank you. So 13, I do rely very heavily on the first sentence. Not permissible to dress up what is in reality a factual dispute, as it were, in the direction of law. We're not doing that. But I'm grateful for this. So then we can go on, deal with abnegation of self-interest. My own friend, Mr. Ramsden, made a submission that there was no question of the developers abnegating self-interest when writing the software code. But that isn't the point. The point is that when writing the code, they cannot prefer their interests to those of the owners of the digital assets. That's where the self-abnegation comes in. Not saying you must stand back from this and you cannot write the code, you cannot continue to operate and run the networks. We then move on to imbalance of power. Fundamentally, whether there is an imbalance of power is a question of fact. And it's simply not open to my learned friends to invite you to form a concluded view about this. But in any event, their attempt to argue that there was no imbalance is hopeless. By acquiring digital assets on their networks, investors are clearly placing trust and confidence in the developers. In circumstances there is a clear imbalance of power, because their ownership interests and their right to access their assets can be abused. They are not in a position to stop the developers taking such a course. And that necessarily means we are dealing with an imbalance of power here. My own friend also sought to make a point about the width of the fiduciary duty we've argued for in this case, but I'd remind you of paragraph 42 of our particular claim, which limits the case in the alternative to a case of fraud. And this is a complete answer to drawing any conclusions from the analogy of throwing away the keys in a drunken state. My own friend also, this is my own friend Mr. Ramsden, also made numerous references to open source posting on GitHub. And yet that's yet another attempt to deploy, in aid of his submissions, his factual case, which is highly controversial. Our case is that the respondents who control the networks and decide what software is adopted by using what's called the merge commit process. And that's done by these defendants. And the evidence, I'll draw your attention to two passages of the evidence, if I may. The first is a supplementary bundle, tab 8. This is second witness statement of Dr. Wright, and it's paragraph 10. I don't want to take you through all of it. Paragraph 10 is explicitly dealing with the argument that was run that here we have over 800 contributors currently listed on the main GitHub repository. And he says, he deals with that in subparagraphs 10.1, 10.2 and 10.3. 10.1 he says that our position is that we're suing the people who control it. 10.2 he then deals with GitHub and makes it clear that the fact that someone's making suggestions on the GitHub repository doesn't mean they're able to make any changes. And he draws the analogy with Microsoft, which itself is open source, but it doesn't mean that any Joe can come along and change what Office does. And he goes on at 10.3, again confirms that the power to approve software changes is held by a small group of developers, and he goes on to explain about the merge commits. And if we look also at tab 11, page 85, the same bundle, paragraph 13, there's no consensus methodology for the inclusion of code. This is purely decided by a small card of individuals acting in the form of a partnership. So my learned friend's numerous references to open source and consensus is, we say, completely inappropriate for this purpose of this appeal, because it's based on his factual case, and we have to proceed today on the basis that my factual case is correct. And then he says, next point is, it's argued that if a duty does exist, a fiduciary duty does exist, it doesn't extend this far. And the short answer to that is this, to ask the question, well, why on earth not? If it's easy to write a patch, why wouldn't a fiduciary in the position of developers do so in the case of an obvious fraud? Once you can be required as a fiduciary to take a positive step, why should you not be required to take the step in these circumstances? And for this analysis, one has to assume they have complete control, they've been paid for their services, and they can implement a patch with ease. And why wouldn't a fiduciary duty extend that far? And when one then have to ask the question, well, what would be the scope of the fiduciary duty if it doesn't extend to that? What possible other example can one think of where they would be required, where they might be acting in breach of the fiduciary duties, other than them writing malicious software, either to benefit themselves or to prevent my client or someone else having access to their private keys or being able to use their private keys? We say eminently arguable. There's then a debate about no entrustment of property. The pleaded cases, there was entrustment, and the judge appreciated that. See paragraph 65 of her judgment. In any case, the extent to which we have entrusted our property to the developers is a matter of fact, not legal analysis, and not for a decision now, unless we have a mini trial. And we say the fact of entrustment arises once one realises that the developers control and operate the system, and they are in a position to change the software so as to damage our interests. And that satisfies the concept of entrustment. My learned friends then seek to persuade you to reject our submissions about this, again by relying on disputed facts. In particular, Mr. Charlton placed considerable emphasis before you on the unidentified and fluctuating body of developers. However, it's our case that they're identified and are limited to a small pool of individuals who are before this court. The extent to which they fluctuate wasn't addressed, as far as I can recall in the evidence. And then Mr. Charlton then argues that there can be no entrustment because TTL haven't carried out any transactions since the creation of the new networks. That's a new point. There's no respondent's notice about it. In any event, it ignores the fact that entrustment arises because of the ongoing role the developers undertake in relation to their respective networks. And we say it's no different from tracing the proceeds of trust property into the hands of a constructive trustee. It's not at all clear the basis on which the judge concluded that we couldn't make out a case for an entrustment. And I didn't hear anything from my learned friends to justify why they're saying our case on that is hopeless.
Well, it's not like tracing into the hands of a constructive trustee, is it? Because we're not concerned with the previous Bitcoin. It's new property.
It's new property.
And it's not new property which represents the old, it's
No.
completely new property.
That's a fair point. But then I limit my argument to saying the entrustment arises because of their operation and control of the network. They effectively have control over our assets. And to that extent, we should be treated as having entrusted our property, even if the new networks arose subsequently. Once our Bitcoin are in them, we're vulnerable. And that satisfies the concept of entrustment. We then deal with the risk of competing claimants. We say this risk is wildly overstated. In most cases, in the usual case, the defendant, the defrauded individual, would be able to prove ownership without anyone else entering the fray, unless the developers want to contest it or want to put him to proof. And there is no reason to think there will be a greater proportion of rival claims in relation to digital assets than any other class of property. The courts aren't full of disputed claims over ownership of properties. There are some, but when measured against the total class of assets in each property class, they represent a tiny, tiny proportion. In any event, the duty of care is owed. The fiduciary duty is owed to the true owner. And there was my Lord Justice Lewison asked a question which suggested that might give rise to a difficulty in our case. We say it doesn't. If you cannot say who the true owner is, let the court decide. It's no different from two or more people claiming to be the true beneficiary under a will. The personal representatives still owe fiduciary duties to the real claimant. And the fact of competing claims doesn't undermine that. Similarly, trustees may be faced with competing claims to assets held on trust. That doesn't inform the question of what duties are owed. And we think there's a point of principle here. The court assesses the question whether someone is a fiduciary by applying the relevant test to him or her. In other words, it applies the propositions that emerge from the authorities that I've taken you to. If the conclusion, yes, he is a fiduciary, or probably is for our purposes, the fact that his position as fiduciary might expose him to practical problems in practice is neither here nor there. If it goes with the territory, it goes with the territory. And we've already made the point, which the judge accepted, we're not in the territory of any voluntary assumption of responsibility. The obligation arises from undertaking the role. There was then some debate about declarations in personam. As far as I'm aware, we've never argued that any declaration would be in rem. I don't see how we could. And during that debate, Lord Justice Lewison identified a problem about serving someone in China who turns around and says, I know nothing about this, what is this all about? Well, I'm not sure if that will ever arise, and I perhaps ought to explain why. On our facts, the developers, who are the relevant parties, we say, will be before the court. And it's very difficult to see how the situation might arise about someone being served abroad. The developers are before the court. If the English court is hoodwinked by a fraudster in making a declaration as to ownership which is false, what will happen then? It will make an order which will result in the fraudster being able to access assets to which it has no real entitlement. And presumably, and I have no evidence about this, but I'll make the point, presumably that order would appear on the blockchain. In due course, the true owner discovers he can't access his personal keys. He will then discover he's been defrauded. So either you'll make an appropriate application of that before this court, or you'll go after the fraudster. It's very difficult to postulate a situation of someone being served somewhere in the world and saying, what's this all about? We are going after the people who control the networks. And so the only possible risk is someone turning up somewhere else in the world and saying, you've handed over control of my digital assets to someone who's not entitled. And the short answer to that is, well, we are acting in compliance with the court order in most jurisdictions.
Well, that's the point. Is it the short answer?
Well, we say it is, and I can't develop that any further on the evidence before you. And it would be a matter of expert evidence. I mean, most common law jurisdictions, you'd expect the answer to be the short answer.
It's a short answer, but it may not be a good one.
It is what it is. But it's exactly the same as I think the point I made yesterday for the Bray Benjamin order was made. That doesn't stop someone else turning up somewhere in the world and saying, well, look, I am the beneficiary. You've handed over control to someone you shouldn't have done. Someone armed with a Bray Benjamin order would be exposed to exactly the same risk, and you don't look at that to ask yourself the question, what duties are in? That's the tail wagging the dog. Point is then made about undue influence. Well, yes, that may raise issues of imbalance of power. But so what? In an undue influence case, the defendant hasn't taken control of the assets in circumstances that give rise to a relationship of trust and confidence. And then my learned friend raised the spectre of the class of person to whom duties might be owed. But this case is about duties owed to people who are resident here. It's not about other jurisdictions. And Mr. Ramsden then said it was a point against us that Quincecare relied on an agency basis, but that's a point that's in our favour, because an agency gives rise to a fiduciary relationship. And the fact that our fiduciary relationship arises in equity rather than in contract is neither here nor there. Turning now to some of Mr. Charlton's points. First of all, he says that the draft amended pleading is procedurally defective because the proper defendants are not before the court. Now that, first of all, isn't in his respondent's notice and isn't therefore open to him to argue. But in any event, the argument is clearly wrong if you look at the 3 points in the Bank of New York case. First condition is there must in general be a real and present dispute between the parties. On any view, the parties here aren't ad idem on the issue of ownership, and there is therefore a dispute. An issue is either agreed or in dispute. A non-admission puts it in dispute. There's no third category. In fact, they have denied our ownership. Both D2 to 12 and D15 to 16 in their evidence below made it disputed our ownership and disputed the hack. And Mr. Foster, on behalf of D15 and 16, disputed our ownership. So it is an issue in this case. The second condition is each party must in general be affected by the court's determination. Well, that's clearly going to happen. If the court finds that TTL doesn't own the assets, it would necessitate that TTL wouldn't be entitled to the relief sought, so that test is clearly met. And thirdly, the court must be satisfied that all sides of the argument will be fully and properly put. Well, they don't have to challenge our ownership, they've chosen to do so. And they put forward a massive material below explaining why they say we're not the owners. So the material will be before the court. The next point, finally on that, one can test it this way. Let's say you have a case where there's no rival claimant. No one's ever suggested that the person claiming to be the owner is not the owner. Well, the only possible defendants in those circumstances are the developers. There is no one else. And then it said that the duties are conditional upon the court's declaration. And it said that by making the declaration, the court would be creating legal rights. No, it wouldn't. Before I deal with that, again, it's not in the respondent's notice. It's not open to them to argue this. And in any event, Gurrier says for the court to have jurisdiction to declare any legal right, it must be one which is claimed by one of the parties as enforceable against an adverse party to litigation, either as a subsisting right or as one which may come into existence in the future condition. But the argument they run makes no sense. If we get a declaration, shows that we are currently the owners of the assets. That is a subsisting right. The declaration doesn't create the right. Our duty of Mr. Charlton then said there's been no fraudulent transaction. Well, there's been a hack. There's been a theft of the private keys. Mr. Charlton then deals with duty of care. Says that all duty of care cases involve harm caused by third parties as a result of breach of duty of care. But in our case, the duty to take care involves the obligation to ensure that the owner can access its assets after a hack. The breach of that duty allows the assets to be stolen and the harm caused. Then he deals with the fact that generating income from sponsorship, that's not inconsistent with the duties being paid. It might be, sorry, not inconsistent with the duties being owed. It might be different if they were taking our Bitcoin, but trustees can be paid, agents can be paid, and the fact of payment doesn't impact on the question of whether or not fiduciary duties are owed. Finally, back to the pleading point. We say that what might be characterised as the renunciation point means that there is a subsisting course of action. But if we're wrong about that and then you get home on the amendment, I would submit it would be quite wrong in principle to direct that our clients should pay all the costs up to date. The reality is that the bulk of the costs incurred in this case would have been incurred in any event if the amended pleading had been put in first time round. The waste of cost has been minimal. But I would invite you to leave that issue.
Well, I think we cross that bridge when we come to it.
Yeah, that's what I was about to go on to invite you to do. My lords, can I just turn around for a minute? Unless you have any questions. Oh, my lords, I do apologise. I was asked a question about bailment. We have brought to the court extracts from Palmer. I don't know whether you want to see it. We provided copies as often to the other side. I wasn't.
What's the answer?
Sorry?
What's the answer?
The answer is not automatically fiduciaries, but often are. The fact of the commercial context probably points to the fact they're not. But we would say, if you have a chance to look at it, the relevant passage, that the discussion very much reflects our submissions before this court.
All right.
I'm sorry, my lord, some I am being. Yes, I'm asked to tell you that one final point, the D14 actually wrote a letter disputing ownership. So I'm not sure that goes any further beyond what I've already told you.
Right. Thank you.
My lord, just on the bailment point, we did research the point overnight, and if I could ask the learned associate to hand up one case which may help your lordship's deliberations. It's where a fiduciary duty was found in a particular circumstance in relation to the proceeds of sale.
Thank you very much. Right, well, thank you very much for your very interesting arguments. It will not surprise you to learn that we will reserve our judgments. You will, in due course, get drafts. That will be your opportunity to correct our English, not our reasoning, nor to raise new points. The draft comes with a strict embargo, which means what it says. It will be distributed to those who've given their email addresses to the court before this hearing began, and any breach of the embargo may be treated as a contempt of court. So the embargo needs to be taken seriously. We would hope that in the light of the draft judgments you will be able to agree a form of order, but if you can't agree a form of order, please make short submissions in writing, and we will make the form of order that we consider to be appropriate. Given the time of year, you may not get a judgment before the end of term, but I'm not saying one way or the other. Thank you all very much.